Human Rights Commission in partnership with the City of Mishawaka CDBG program. We actually have two of our guests from the CDBG program in Mishawaka. We have Marilyn Jones and Laura Viramontes. If you'd like to just quickly say hi or just, Laura?
Hi, everyone. Thank you very much for joining us. And thank you, Diana and her staff and her people that work with her to make this possible.
Thank you. Okay. I think Marilyn shared that she was, going to remain mute, which is not a problem. But her name is Marilyn Jones. Great person to reach out to at the City of Mishawaka. Should you have any questions as well, either to connect to us or just if you have any questions about specific resources for the City of Mishawaka. So my name is Diana Moya, and I am the housing manager for the South Bend Human Rights Commission. I want to share with you that the webinar will be recorded, and we will have a link available to our participants, of course, after the meeting is completed. And that link will be available on our city webpage, where you will also find many pages of resources, whether it's for housing, employment, any of the areas that we enforce. We are an investigatory agency, but part of what we also do is tasked with education and outreach. And that is why we have this informational session today. For today's session, we will cover two specific programs within St. Joe County, specifically the St. Joseph County Emergency Rental Assistance Program and Indiana Legal Services. The reason why we are bringing this information today is because we are drawing near to the eviction moratorium that is set to end on June 30th. And so we keep hearing the tsunami of evictions, or that is forthcoming, after the 30th. And so the concern is that there are still resources out there available for the community, and we're hoping to again provide either direct information, direct contacts, so that if you or someone is experiencing the economic hardships or what is coming, if an eviction is the situation, that you have those resources available to you. And then as of today, we have not heard if this moratorium will be extended. So let's get started. I'd like to welcome our two guest speakers. The first speaker we have is St. Joseph County's Emergency Rental Assistance Administrator, Corey Szcyzypka. And then we also have Indiana Legal Services Staff Attorney, Kylee Tomblin. And I apologize again if I am not pronouncing your names correctly. Please educate me if I am not. But Corey will present first, and then we'll hear from Kylee. And there will be times for questions and answers after each session. If you have a question that you would like to ask, please either type it out in the chat area or raise your hand and we will try to get to you. Ladies, I hope you don't mind if you're interrupted during your presentation if there are questions from the audience. And so again, we have until noon. We may end before noon, and that's okay too. But just again, if you miss any of this information today, again, it'll be recorded. The link will be available. And if you would like, we have this session occurring also on the 24th, which is next Thursday, same time, 10 to noon. And so you're more than welcome to join us at that time. And for that, we don't require any early registration. I am going to ask folks to please mute themselves just for the purpose of the information that will be shared. So I thank you so very much for that. So before turning this over to Corey, I'd like to share her bio. Corey is the St. Joseph County Emergency Rental Assistance Administrator, where she manages and coordinates county resources. She graduated from the University of Oklahoma with a master's in public health. After she graduated, she lived in Augusta, Georgia, and for 5 years working in a post-award grants administration at Augusta University. Corey's most recent experience with the St. Joseph County has been as a COVID-19 administrator. So everyone, let's welcome Corey this morning. Good morning, Corey.
Thank you. Good morning. You hear me okay?
We can. Thank you.
All right. Thanks for inviting us. I'm excited to get the news out. We've been doing some advertising and some news articles and press releases and that sort of thing, but we're really trying to first just address the demand that we already have before we create an influx of additional cases. So let's talk about the program a little bit. So rental assistance program, this is designed to decrease evictions, increase housing stability, and prevent homelessness. And that's the Treasury language. This information was provided. We can, in our area program, provide up to 12 months of rental assistance. Utility assistance can also be provided on an arrears basis, and home energy expenses can also be included. So, like I mentioned, this is the U.S. Treasury Rental Assistance Program that St. Joseph County was awarded funds from. Us, Elkhart County, and Lake County, and a couple of other counties specifically spearheaded off to have our own programs. The rest of the state falls under IHCDA.
Mm-hmm.
And you guys are familiar with that program that has been running since 2020. So we kind of pulled a little bit of the funding out to have a separate program here for us. And so that's what we're giving it a go for.
Wow, that's great. That's great to know. So I want to ask a question. You mentioned that they have that, tenants are eligible for the rental assistance and utility assistance. Do those go hand in hand? Can they be separate, or how does that work? Or if you don't qualify for one, would you qualify for the other?
Yeah, they do not have to be combined,
Mm-hmm.
but the applicant must be a renter. So
Okay.
the utility assistance does not apply for homeowners. But if they are not behind and do not need help with rental assistance, they can still apply for utility assistance only.
So does the utility have to be in the renter's name? Because I know that in St. Joe County, that is often not the case. It's usually in the landlord's name. So how does that work?
The utility can be in the landlord's name as long as the service address indicates the rental property.
Okay, thank you.
Mm-hmm. Going to the next slide. Do I have control, or are you doing it? Oh, there we go. All right, excellent. All right, so for eligibility for the program, you have to meet all of the following, and these are provided by the U.S. Treasury, so we have to follow their guidelines on these, but they're currently a resident of St. Joseph County. Your name appears on the rental lease. In situations where a tenant is renting from a family member or that kind of situation, it doesn't necessarily have to be a formal, a formal lease, as long as it's written and it can provide identification of whom and who the money goes to and who's responsible, and household information as well. And we may, in those situations, we may ask for additional information to verify that, there was in fact a lease prior to COVID, if that makes sense.
Mm-hmm.
So we'll verify that information. But just because you're a family member renting from another family member doesn't necessarily disqualify you from the program.
Sure. What about leases that have expired or were not, of course, weren't renewed, or it's a month-to-month lease, where terms and conditions might be a little bit different. What about those types of situations?
We like the original lease that shows, who the responsibility is for, and then the landlord can provide something if it's a month-to-month or any other type of situation moving forward, and that's okay. We have lots of month-to-month type living arrangements, so that's not a problem.
Okay. What if the landlord doesn't reside in St. Joe County, may reside out of the country, that type of thing? And again, may not necessarily have a formal lease or maybe no lease. What about those instances? I mean, do they bring in their bank statements showing that they paid rent, or and I'm sure you'll get into the documentation portion.
Yeah, we will try to get as much landlord cooperation as possible. And even though they don't reside here, we would still try to contact them by phone and email to at least get some kind of communication to provide documents, whether it's an informal lease or formal lease. And then, a bank statement would show where the payments have been going consistently, hopefully before now, to this entity.
Right. Thank you.
Okay. Income, you have to meet an income qualification of less than 80% of median. And I mean, that's a general program. I think CB DG follows similar program rules. So those are the numbers there for the household, and anyone in the household 18 or over, their income would be eligible to include in the household income. Oh, can we go back to the first one? Sorry. There we go. So the income limits, and then demonstrate housing stability or risk of homelessness due to COVID. This is the hardest yet easiest to account for. All right. So we first off want to get all the proper documentation as much as we can. So we know that we can prove risk of homelessness, instability of homelessness with high utility bills. Kids have been home during the year because they didn't go to school. We have extra food cost, extra utility cost, extra daycare cost, or daycare closed. So then we have those individuals at home that can't go to work. So I mean, there's lots of examples of what can fall into this category. And so it's really hard to pinpoint. You have to provide this, and this, to qualify. So it's all case specific. But we do, I think I have some information a little bit later on that we'll talk about that.
Okay. Corey, it looks like we have a question.
I do have a question. Now, this has been brought to our attention a few times by other subrecipients. How are you dealing with pre and post COVID? Because a lot of these families didn't qualify pre-COVID, but they would qualify now as far as income guidelines go. Now, are exceptions being done due to COVID and families being affected?
Yes. So there are some situations where if their income is too high for the program as of today, but then maybe in November of 2020, they lost their job and lost their income. So we can take, and then, obviously we would try to make sure that the need was in that time period too. So if they had $3,000 of arrears that were owed before COVID ever happened, we can't include that amount. But if they were needing assistance during the time period, and that was the time period, they can provide pay stubs that their income was dropped, or that a letter from their employer saying they didn't, they were laid off temporarily because they didn't have the business closed for COVID. Those kind of exceptions definitely are involved. So each case is, like I said, a little bit different, but we can account for those as well.
Okay, great, thank you.
Mm-hmm. All right, so other eligibility requirements is they must meet one of the following and provide documents as proof. So unemployment benefits, that's pretty straightforward. The unemployment benefit does not necessarily need to be COVID related. However, they do still need to meet the housing instability or homelessness reason. So we don't have, it's really hard to try to figure out from an employment statement if they were receiving unemployment because of COVID. So that's kind of the requirement there. An applicant household experience a reduction in income due to involuntary job layoff, reduced work hours, or reduced pay. And that's fairly straightforward. I mean, you provide the pay stubs of a reduced work hour or something from their job saying a layoff. We know lots of jobs closed. We haven't seen too much of the reduced pay as far as an hourly rate going down because of COVID rules, and you know what I mean? But if there were some of those, we could address those. And then an applicant household must incur significant cost or experience a financial hardship due to COVID-19. And this is kind of like the first instability risk. There's lots of different documents and reasons. So we just kind of have something to show that this is the time period and this is really what happened. And then including all of those, there is the opportunity to provide just an attestation from the tenant and or the landlord and or a caseworker that's been working with one of these families. So in the event, a business closed and we can't get a document from an employer, or we can't get pay stubs, we can accept tenant attestation, that this is what happened. Obviously they're signing that form or attesting to that information in their application. So if they provide false information. We can only investigate to a certain degree, and then we're going to use their attestation and provide that as their document backup.
Corey, I have a quick question about the last point at the top of the eligibility that says demonstrate housing instability or risk of homelessness due to COVID-19. What kind of documents are you seeing with regards to that? What are people bringing in to show that?
I actually have another slide on that too. So we'll move forward, and then there's some examples on there, I believe, if I made it right.
Got it.
If not, we'll come back around to that question.
Okay. No problem.
All right, go ahead. And then we looked at that one already. Good. All right, housing instability. Here we go. So these are different ways that we can prove housing instability, that there's a current housing cost burden, and that would be that the household pays 30% or more for total income or rent. So what we would do is, once we determine the income for the time period, we would check the rent and do that calculation. And if it's 30%, which a lot of them are, especially if unemployment's involved, that the unemployment is going to qualify them for the 30% category. Double or tripling up with other households, creating unsafe or unhealthy living condition. And it's going to be an attestation for that type of category, because there's nothing really a household could provide, unless they had some kind of benefits letter that said multiple SNAP benefits per household or something like that. But we can just take attestation for that. Accumulation of unexpected back rent or utility payments, and those can be evidenced by bills, and it'll show the high amounts of back owed utilities. And then other risks, such as informal rental arrangements with little or no legal protection. We haven't had too many of that information just yet. Evidence of delaying a purchase of essential goods. So if they provide receipts for prescription drugs or childcare, or transportation, or just something to show that they have these extra costs that they don't normally have because of a situation of COVID. And we've had a couple, this includes, healthcare was not shut down, but limited for home health for many patients. So, they lost their in-home care, and those caregivers often provided essentials such as bandages and medical needs and things like that were included in their home health. And if these tenants, especially low-income residents, weren't able to get that assistance, they had to pay out of pocket for those costs. Mm-hmm. So some kind of statement showing how much they incurred or what kind of thing, so there's a broad area of what can be included. Like I said, it just depends on the situation. But we do see a lot of the daycare, child care receipts that, they were originally needing daycare, but now they do because their children can't go back to school. Mm-hmm. Those kind of things. Evidence of household relying on credit cards, payday lenders, or other high-cost products, depleting savings. So we could look at some bank statements if we had to. We try to stay out of banking areas, but if they can't provide any other documents, we could look at that rather than wage or income. And like I said, this is not an exhaustive list. It really just depends on the household and the risk they're experiencing. Yes, so that's does that help? Does that answer your question just a little bit?
It does. So rather than an applicant perhaps looking at the information as it's presented, whether it's, they see a flyer or, whatever the case may be, it's probably preferable that they call, correct? To because they may think, well, I don't qualify, but they may qualify depending on what other documentation they do have. So it's probably best that they call, right? Is there like a screening process that occurs when they do call in, or when they?
No, there's the 800 number that we have, 6242, 800-6242. It is an informational line that comes, if you pick option 4, you can talk to me directly, but it has a lot of information on how to apply and information on the program. But there's no pre-screening process as far as on the phone. Like, I can tell general information, or I'll direct them to the website. But once you go through the application, it's on a question by question basis. So if they select one of the criteria, it'll give them options on how they believe they would qualify. And as long as they're, going through and picking options that truly qualify them, for their experience. The application will go through to a caseworker, and then the caseworker can ask additional questions. The main criteria for a denial up front is that if they don't live in St. Joseph County, they put something way too high as their income, like, $300,000. They just accidentally put something incorrectly. And so those were the things that will automatically kick out an application to start with. But once they go through the process, and we are trying to get a little more phone support. So we'll have some people that can answer more questions about program and policy and how this might affect some people.
Right. So Corey, are there any other, so is there assistance though, if a person has difficulty filling out the forms online, say for example, they don't have access to the internet, or maybe just not know, how to, find the website, that type of thing. And language assist, is that, and then for our folks who may have some type of an impairment, what do we do in those cases?
We do have a couple. Well, we have 2 of our partner agencies that are starting walk-ins.
Okay.
So we haven't just released all that information out in the web yet, just because we're trying to get our processes involved. But if individuals call me, and say, hey, I'm having problems with the application, or I don't understand it, or I can't figure out how to upload things, then I direct them to the walk-in sites and give them times and addresses. And then I've had a couple come up here to the county building and say, and so I can accept a couple of landlord walk-ins, to scan documents and things like that. And then the library and then Goodwill's helping as well. And I know there's a couple of other partner agencies that are just advocates. So they're helping clients fill out applications on their computers and kind of walking them through how to get documents uploaded and stuff like that. So they're not necessarily partners of the program, but just advocates of the program. So we have those agencies out there as well.
Okay.
And I know Indiana Parenting Institute is going to be out at Juneteenth. Does that sound right? With some literature and things like that. And then once we get kind of stable on the application processing, we are looking at doing some additional outreach as far as maybe trying to do some door-to-door type outreach and things like that, because we do know there's a large part of the community that cannot get somewhere, or we just can't assist them technology wise. So we are going to try to address that the best we can, but right now we're just trying to focus on getting the application process smoothed out and working smoothly. So
okay, thank you for that.
All right. So how much assistance can a tenant and or landlord receive in this amount? So the full amount, I went dark. Y'all can still see me, it's okay. The full amount of monthly rental assistance can be paid up to the published limits. And we've been trending that most of the apartment complexes and landlords, they are under or right at the limit for HUD. There are a couple of complexes that, a 2-bedroom would be $937, for example, or some weird little number like that. So, in that case, we could only pay up to the $851 for the rental assistance for that tenant, and then the tenant would be responsible for the additional amount. Back owed and arrears can be not to exceed 12 months. So as our timeline reaches out a little bit, at first, when we first started, it was like, up to April 1st was an entire year. But now we're moving forward a little bit, but it's still up to 12 months and in back owed arrears. And then forward facing up to 3 months to ensure housing stability. So I know on the original side, we said 12 months, but it can be up to 15 months. So if a tenant owes 12 months of back rent, and they qualify, we can do 15 months at a time, 15 months in one setting, but that would be their entire award. Okay. If they only owed 3 months back and needed help in the future, so we could pay 3 months back, 3 months forward to make 6. And then if they needed additional help after those 3 forward-facing months were approved, they could reapply if they still qualify and receive an additional 3 up to the 15 that they can be awarded. So that's
Okay.
kind of the process goes, and it can be a little tricky, you know what I mean, to some clients, but our main goal is to get the back arrears paid and then help them out a little bit for the next month or two to get back on their feet. And
So-
hopefully after that part, they won't need any additional assistance moving forward. That's what we're hoping. But there could be cases that, you know, they're just not quite recovered or, you know, that sort of thing.
Sure. So Corey, I have a question. So would this include any kind of maybe sometimes when we have tenants, they kind of share, look, I paid part of my deposit, I didn't pay all of it, I still owe it. Does this just cover specifically what they're in arrears, with the exception of maybe perhaps that they made a partial payment on a deposit, or how, or their landlord raised the rent during the pandemic, which, in Indiana that they can do that. What is this just specifically for rent, or does it include any other factors?
This specific chart is only for the amounts of rent assistance, but that does not include late fees.
Okay.
Late fees, any kind of fees that are approved anyway can go on top of it. So I've seen like filter fees, like things that are involved in the fee. They owe a check processing fee, a late fee. Now we cannot assist with deposits that are not COVID related. Okay. So if there's a deposit from 2019 still left on there, that would still be the responsibility of the tenant. But we won't pay. We aren't able to pay like washer dryer fees, parking fees, those extra things that are a convenience. But for the main part of the fees, that we are able to include those, and that can increase their assistance award past this chart, depending on how much they owe. Okay. And then we do know that not all landlords were charging late fees during the moratorium. So we're trying to be as expedient as we can, you know what I mean, to not accrue additional fees, but we're working on it. Okay.
And if there's an increase in the rent, do you take that into consideration as well?
Yeah.
In the forward facing rent?
Yes, we can do that. We just need to make sure that we have an updated lease or something from the landlord that's saying, we aren't going to be able to pay any additional fees if the landlord added on a fee because the tenant applied for assistance. We ask them not to do that.
Right.
But other than that, we'll pay those late fees and that sort of thing. That's in that. Some of them have been rather high, but as long as it's in the lease that amount can be charged, then that's what we're gonna take care of.
Okay, thank you.
And that amount also doesn't include if they're the utilities that are owed to the landlord. Now, some of the bigger complexes have in their ledgers include trash, water, services. So those that are in addition to the rental amount. Oh, utility assistance. All right, so this one is a little bit different, that we're only paying back owed amounts and arrears on utilities. It's just too hard for us to figure out 3 months in advance, how much a utilities bill is going to be. So we'll pay up to the amount that's listed, and we would make a pledge to the utility company to make sure that disconnects are not occurring while they're waiting on our payments to come. So that's a little bit of a lengthy process, but and these household amounts were based on some information that IHCDA was using. They gathered for us. So we've seen some right at the edge of the limit, but so far no one's been going over, so we haven't had a need to readdress the numbers in this chart. But per number of bedrooms, the amount goes up depending on their income size and household size.
Okay.
Internet assistance is also a little bit different. The Treasury doesn't quite consider it a utility. So for budgeting purposes, it comes out of a different pot of our budget. So we can do things just a little bit differently. And we're going to provide a one-time assistance payment of $300 per qualifying household. They have to use the internet for one of the eligibility requirements below, which would be telehealth, telework, school, or if they're actively receiving unemployment and they use the internet to requalify, or however they check their unemployment or other, benefits as far as that goes. And then the telehealth, if I didn't say that. So, a lot of the school age children fall into this category. So, and these are for, we have one internet provider that we're working with right now. We're trying to get another one on board. So we just have to make sure, but that one-time payment. So we do know that this may create an overpayment situation on this utility, but we are expecting the tenants to use out their, overpayment to continue their services. So
That makes sense.
all right, and how to apply. So we have online application. We do not have paper applications. However, we did discuss a little while ago that we do have some walk-in opportunities and assistance type help. But these are our partner agencies that are taking applications. So these individuals can answer program questions if you get a hold of them, or or specific questions about how the process works or their application in general. So. And then this is just my information. And then our nice little legal thing at the bottom for our legal person that's here that I forgot to put on the first one.
No problem,
So,
we get it.
So that's basically the program in a nutshell. Some frequently asked questions that we get are about how the income is reported as far as the assistance payments.
Yeah.
The landlords are, it will count as income for landlords, just like it would any other rental income. But for tenants, it is not counted as income. And then there are only certain situations that we would send a payment to a tenant anyway, and that would be when the landlord is not cooperating in the program. They've refused to participate, which is totally their right to do so. You know what I mean? There's lots of reasons for why that would occur, but we do have a couple of landlords that have declined to participate. So what we do in that situation is that we write the check directly to the tenant and then have a second endorsement of the landlord. So it would take both parties to cash the check, because we do have to have some kind of fraud prevention as best we can. So
Corey, what happens if you send the check out and the landlord is still refusing to be the to provide the signature on the check? What happens in that instance then?
We have not had that situation,
Okay.
but we'll get to it if it comes. I suppose.
Okay, and I'm assuming it's because nothing is signed at that time. There's like no contract between the landlord stating that they're obligated to receive those funds, and it's basically just for their arrearage. And is that correct?
Yes.
Okay, so I have a couple questions. So if the applicant has applied or received assistance from other organizations, and they were it was COVID-based assistance, can they still apply through this program?
Yes.
Okay.
What we would do is, we would have to include the payments they received, if that makes sense. But because we can't duplicate the payment from, like, for instance, IHCDA payment, we can't duplicate that payment, but we can pay the other amount from that month that was not covered.
Okay.
So any tenant responsible amount past the assistance payment. And if the same thing for Section 8, even though it's technically not rental, like a COVID rental assistance, it is rental assistance. So that doesn't disqualify the individual. What we would do, we would just, most of them on the ledger, it already shows where an assistance payment is coming in, and then the tenant owes, whatever the remainder is. And then that's the part that we would assist with. We can't double up on the payments, but we can do the tenant owed portions.
Okay, so it can't be duplicative of any other federally funded program, is that correct? Okay. Yeah. So, and I want to ask, so as far as housing is concerned, we always think about, they're renting a house, but does it include any other housing situation? Say, for example, does it extend to a hotel stay, or forced hotel stay, mobile homes, or manufactured homes, does it extend to any of that? Or land contract based as well? I mean, sometimes those land contracts end up being more like rental agreements than they are, a rent to own. So what happens in those instances? Does it apply?
Yes, all of those can apply. We do have some of the mobile home where it even gets tricky for me, where they rent part of it and own part of it, and as long as the rental part has the leasing information in it, then we can take care of mobile home lots. Like you said, the property where they're rent to own kind of situations, or I've seen a couple that are rent, but at the end of their first year, they have the option to buy, those kind of leases. Those still qualify as well, as long as it's going to show that the monthly amount that's paid, and we know that they didn't pay the deposit for the, I don't even know what to call it. You know what I mean? The deposit for the purchase price. It's in the contract, but they didn't pay that yet because they're just renting. So we can take those. I've processed a couple of those actually.
Okay.
And then motel stay. So we do have a policy that includes motels. We haven't seen very many of them yet. We kind of anticipate the need to rise in the next month, but we do have a little bit of a different process on that, just because the hotels are not landlords. You know what I mean?
Right.
They essentially act as a landlord, but there's no month-to-month lease agreement. They could walk out at any time, or you know what I mean? So we have a little bit different process with that, but tenants can still apply if they're in a temporary housing situation like that. And in that case, we know we would try to pay any arrears owed to the landlord, and then help them out with the current need in the motel. We just got to make sure that we won't pay 3 months in advance, because we don't know that they would be there for 3 months.
Right.
But we would try to do a 3-month eligibility, and then a 1 month at a time check and that gets a little bit more costly than a regular rental. So we're just treading lightly until we have a huge need to change it a little bit. So it is possible though.
Okay, and I know that I had heard earlier that the landlords can also apply on behalf of a tenant. Is that correct?
It is. That's something that we finally got working on our system. So yeah, the landlord would go in and apply on behalf of the tenant. And this can help us capture some tenants that are unable to fill out an application themselves, or maybe they're a little leery of doing so for whatever reason, but in that process, the tenant does still need to participate. We can't accept income documentation from a landlord for eligibility. We still have to make sure that the tenant agrees that this is correct, and they provide household information and that sort of thing, so we're not duplicating services. So unlike the tenant application where the landlord doesn't have to participate, when it's switched around, the tenant does need to participate in a landlord application. But at least it's an avenue, so that we can reach out to these folks and say, hey, come on in, your landlord's trying to help you out here.
Right. So if it's an apartment complex, can they apply for more than one tenant if they're in arrears due to the COVID situation?
Yeah. They would just need to fill out a separate application for each person, because it would definitely be tenant dependent.
Okay. I have a guest on the line. Her name is Vicky. And Vicky, are you on? Can you hear us? Vicky?
I'm here.
Hi.
Hi.
So we chatted briefly yesterday, and she shared some information that I thought was interesting, and I invited her to share that information with regards to actually going through that process. Vicky?
Just that we have had a couple of residents apply, and we completed the paperwork. And Corey, I actually got stuck somewhere and spoke with you, and you walked me through it. It was a pretty simple process, and we got our payment in a reasonable amount of time. You let us know when we would be getting the payment. We've encouraged other residents to apply. We haven't had a lot of them apply, which is concerning, but you know, you can only do so much, but the system worked great for us.
Excellent.
Mhm, mhm.
We
So
do like to, you know, normally just in any other customer service situation, we do know that we normally get a lot of negative type calls. So it's, you know, with problems. So I'm glad that, that your process is going smoothly.
Yeah, I mean, it was a pretty simple process. If I can do it, anybody can do it. And, you know, we are notified when the person is accepted, told how much the payment will be, approximately when it would arrive, and it did. So we were very pleased.
Wonderful.
thank you, Vicki. I appreciate you.
You bet.
So, I do have a final question, and hopefully, if anybody has a question, please jump right in. Either raise the hand or you know, type the question in the chat. But I do have a question. So, what if the tenant has already received an eviction notice?
Okay. Oh my goodness. Every application is a little bit different, but so in our system and per the Treasury guidelines, we have to have three priority case situations. So one would be an eviction, one would be unemployment, and one would be if the income is under 50% of HUD regulation. So once an applicant fills out the application and they indicate, they don't know they're indicating necessarily, but you know, they fill out the blocks accordingly.
Mhm.
They will be flagged for those three reasons to be on a priority list. So we are trying to work off the priority list.
Mhm.
You know, some applications take a day, some take 2 to 3 weeks or more, depending on when tenants and landlords provide information and how the process flow is going and how the checks are written from each organization. So I mean, so if they originally indicated an eviction, we're trying to work those first, obviously. If they didn't indicate an eviction on their application, they can contact myself or one of the other agencies. We can always upload into their application and change the status.
Mhm.
Now, the ones that called today that say, I haven't submitted an application and I have an eviction this afternoon.
Mhm.
But we do get some of those. And some of our partner agencies are a little more flexible on their processing than, like, the county has a lot of processes to write a check. You know,
Mhm.
so in those situations, if I get an urgent, desperate call kind of thing, I can reach out to an agency and say, hey, do you have capacity to look at this one today? It's very emergent. And they can often do a quick review, meet eligibility requirements, and, you know, process the direct need with a voucher to the judge or to the, you know, that kind of thing. We're trying not to get to those situations, but they happen, you know, so we're trying to process them as quickly as we can. But especially on the one where the tenants didn't provide that information on their original application, it's going to get bumped down on the list per se, because it's not the high priority. So if they let us know something has changed, we can definitely, you know, try to address it at that point and move forward.
Mhm. Does it make any difference if the landlord just gave them like a 30-day notice, um, you know, to move, or if they received an actual, you know, document from the court stating, you know, you're being evicted? Maybe the eviction was prior to, you know, the in between the moratoriums as how they fell. Is there any, you know, difference in that, or it's just all considered as an eviction?
We do look at the letter, because some of the landlord information coming out is that it's a notice to pay with a date to move out on it, which is not necessarily an eviction. However, we don't want it to become a true eviction. We don't want the court fees. We don't want the judge. You know what I mean? So we will look at each one individually and kind of determine the urgency of what the letter says. Yeah. So, and then of course we do have the letters that say your lease is ending on July 30th and we will not renew your lease. That's not really an eviction. They're just not renewing the lease. But that still poses a housing problem, because if we have lots of residents with turnover like that, they won't have anywhere to move to.
Right.
You know, so we do take that into consideration, because we do want them to get paid up and hopefully that will entice the owners, not necessarily the landlord property managers, but the owners to let them stay once they get paid up. So we're hoping that will help a little bit.
Great. Is this program going to stay open until, what's the forecast for this particular program?
Oh, originally we were supposed to have funds used by December 31st of this year. They have moved the date out to September of 2022 to use the funds. We are still trying to stay in budget to use at the end of December, but we don't, if we still have budget remaining, then we will continue to use the budget.
Okay, great. Okay. And lastly, I just have a very quick question. So how many applications do you think have been processed since you started advertising this program?
We have, I don't have the last week's numbers. How about that? Last week's numbers, we processed 452 applications, I think.
Okay.
And that was roughly $1.7 million that went out to utility companies and landlords.
Okay.
So I guess this will just be my little plug here that this is to use all our expended allowance, we need to be processing more. So we are still encouraging other partners to join us who have the capability to process applications and make payments. We've submitted, we actually awarded sub-award grants to our partner agencies so they can run their own program. You know what I mean? And so we're with the Treasury guidance, but they're able to do their administrative purposes how they need to. So we are accepting applications for partner agencies to come on board in that capacity. And we're trying to ramp up our processing speed and work out our processes to get things more quickly. We do have quite a few applications that are out there that do not have landlord participation. And I'm going to say most of them are because the email address and phone number is wrong for the landlord, or the tenant filled it out incorrectly. So we are trying to go work through those and get these landlords on, they just don't, they haven't received an email, they have no idea. You know what I mean? So we're trying to address that as quickly as we can because we know it's a looming problem. Some of the newer applications are going through quite speedily, and some of the older ones are kind of stuck in a rut. So we're trying to address that problem. But we're taking more partner agencies. We're trying to ramp up and get things going. But some of the applications are in there. I think last week we had 1,062 applications. So there is a need. There is going to be a continued need. We should trend differently past December once COVID's kind of relieving itself. But right now we're just trying to get the money out to the people who need it, and that's kind of a tricky part.
Right. Well, I hope that this gets out to folks who need the information. And I want to thank you, Corey, for the time that you took this morning to walk us through the process and the program. Are there any questions from anyone in the audience that would like to ask, or any comments or anything at all from anyone? Well, Corey, I want to thank you again. I would like for you to share your contact information again. I think we had a screen on that, did we not? Alyssa, can you bring that back up just so that people have a final contact information? So while we're looking for that last slide of contact information, there it is. Thank you, Alyssa. If you can see, there is Corey's name, her title, where she's located, but her contact number and email is primary to know. So please share that information forward. If you know of someone, or you yourself, if you need the assistance, please reach out. And then, Corey, any final thoughts that you'd like to share with the group today?
Just a final thought. We're excited. The county's never had a program like this that we've run, so we're just really excited to be helping the community. And through these sub-awards, the agencies are getting some administrative cost handled. So that amount's going out back into the community. And we're really glad we chose this direction. And so we're hoping to make an impact.
Well, we are too, and I hope you are. And with 1,000+ applicants, I think that, even though that appears small, but it means a lot. It's 1,000 families that, have some type of relief. So we appreciate that. So Corey, thank you so very much for your time this morning. We'll see you next week on Thursday, hopefully. Okay. And all right, thank you very much. Okay, I'd like to just give a few minutes for our next guest speaker to get ready to join us. I know I saw her here earlier, and there she is. Hi. And I will, before I turn this over to her, we'll share her bio. And again, this webinar is being recorded. We will have the link available if you would like to revisit the information that was shared. And then also, please just know that we will have, we do have a second event scheduled for the 24th, where we will revisit the same information and again, just put forward some really good information out to the community. And again, I would like to, before I get started, before I turn this over to Kylee, is to share her bio with you. So Kylee has lived in the Northwest Indiana most of her life, and she received a bachelor's degree in psychology from Ball State University in 2017, and her JD from IU McKinney School of Law in 2020. Kylee is currently a staff attorney at Indiana Legal Services, where she primarily represents and advises clients with housing issues, benefit issues, driver's license issues, and other civil matters. Wow, that's a lot. That's a lot, Kylee. So I want to welcome Kylee. Good morning. How are you?
I'm great. I was actually super happy to hear Corey's presentation because on the legal side of it, we're always talking about rental assistance and getting the applications and like, do you have any emails from them we could promote? So I was super happy to see like behind the scenes because I usually get to the point after the rental assistance has been paid. So that's fun.
That's good. Thank you for sharing that. I appreciate that. So
Okay.
Go ahead, Kylee.
I do have one slide. It's just my contact info. We can put that up at any time. I do have a time in here that kind of announces it, but so I'm Kylee Tomblin. You heard my bio. I am a staff attorney with Indiana Legal Services. I'm going to talk a little bit about what Indiana Legal Services does generally and who we are, and then I'm going to get more specifically into the types of housing issues that we can assist with, the types of services we give in housing cases, and then some general information and tips that I think that are really important for tenants to know. I really do feel passionately about this. Housing is kind of my bread and butter. It's most of my caseload. And I think there are lots of things that tenants can know and understand about both our services and just their rights in general that can assist them with their housing issues in the future and right now. So Indiana Legal Services is a nonprofit law firm and the largest provider of free civil legal aid assistance to eligible low-income individuals throughout the state of Indiana. We help clients who are faced with legal problems that affect their access to basic needs such as food, shelter, income, medical care, and personal safety. Who is eligible for our services? We generally serve low-income individuals. We consider income and expenses. So just because you think, oh, well, I have a car that I own outright, or I own my residence outright, or, things like that, your primary residence gets expended out. And so the same thing about cars. So a lot of more people are eligible than they think. And so for that reason, I would always tell people apply. If you're not eligible, we'll let you know, but more people are eligible than they think. Another thing is sometimes you can be eligible based on other factors. If you live in a certain county or certain counties, you can be eligible for our services based on your age. So we do have a senior grant for helping people over 60, and that's regardless of your income. So again, apply. If you're not eligible, we'll let you know. But if you are, it's, you're going to get some kind of information and advice from us, anything from advice to, actual representation. Is there a cost for the services? Mm-hmm. No. People always get on the phone with me. I'm calling them and I'm saying, hi, I'm a staff attorney with Indiana Legal Services. And they say, I don't have any money to pay you. I can't afford an attorney. What is this going to cost me? Nothing. We do not charge our clients for our services. I know it sounds too good to be true, free attorney, but that's what it is. It's for folks that can't afford attorneys to get an attorney. And we will never charge anybody for our services. We can't legally.
Do you have income guidelines though? Do you have
We do have income guidelines, and those are considered at application stage. So you'll get asked a whole bunch of questions, you know, when you do apply for an intake, which I'll talk about in a minute. But yeah, that's where the income and expenses come out of it. And so your income eligibility will be affected by your expenses and considered at the time you make your application.
Mm-hmm.
And then the best way to contact ILS, this would be where my slide would be more relevant. You can apply for our services both online and by phone. The biggest thing is if you call by phone, you'll be talking to our intake specialists who ask you all the information up front. And so a lot of times that is a longer, but also more holistic way for us to get the information we need from you. Sometimes when people apply online, which is great, I'm glad we have that tool, but people don't do everything they maybe need to get the information to us. And so our intake specialist will have to follow up with you. And I get really, really disheartened sometimes because I see a lot of folks get called by our intake specialist after making an online intake, and then they don't follow up because they're not expecting a call from us. They think that the online portion's done, that's my application. If you get a call or a text even from us saying we need some more information, please follow up, because we will close your application if we don't get, you know, if we can't get in touch with you. So always be expecting that phone call, especially if you make the online application.
Mm-hmm.
Generally, what kind of issues do we help with? This is a big question that I get all the time. The only thing I would really caution is we don't help with criminal issues. We do help with expungements, which are kind of unique situations. They're definitely related to criminal law, but they're in a civil procedure. They're a civil issue. So we do help with expungements, but other than that, you know, no mistake, it's all civil legal matters that we assist with. So those would include expungements, like I had said, license issues. If your license is suspended, you know, things like that. Benefits, so Medicaid, SSI, SSDI, SNAP, unemployment benefits. I myself help mainly with housing, and then also family law issues, wills, power of attorney, and debt collection, bankruptcy. Those are all the services that we can provide. Now, that's not to say that everybody who's going to, you know, be eligible who applies is going to get, you know, full representation, but you'll get anything from advice, you know, to pleadings that you can file, or forms that we can give you that you can file on your own, to full representation. So it's a spectrum of services that we provide. But again, I would encourage people to apply, because if you're eligible, you usually at least leave with some really good advice that's crafted to your situation, written by our attorneys. And in my opinion, it's very good advice, but I'm a bit biased. So we do have some special projects. Our special projects serve either specific types of legal issues or specific populations. So our special projects, if you'll bear with me, Senior Law Project, the Homeless Legal Project, Immigrants and Language Rights Center, Low Income Taxpayer Clinic, Consumer Law Center, Housing Law Center, the Military Assistance Project, the Legal Assistance for Victimized Adults Project, which we call LAVA, and the LGBT Project. So all of those there's more information on our website, which I can give you later. But basically, if if your ears perk up, if you hear something today that you think, hey, I might need an assistance with that, going to our website and just looking to see if we have a special project, or even if you just fit in under our general services, again, apply. I think that's all I have on generally ILS, and I'd like to get into housing. If anybody has any questions though on the general part of it, or if you did, Diana, before we move on.
Let me see here. No, those are the questions I had initially. Just, you know, the kind of like the screening process, what happens if there are income guidelines, you know, what, just the general. So you thank you for that. I appreciate that.
No problem. I'm super happy to do it. I'm glad that it worked out. So more specifically to evictions, like I said, I do a lot of housing law. I've had 3 hearings in the last week in St. Joe and Elkhart. And so my office is out of South Bend. And so we cover about 10 counties from LaPorte all the way over to Elkhart, and then the counties below St. Joe. And each one of our offices kind of does that. So if you know somebody in Bloomington that needs assistance, we have an office down there too. And when you apply for our assistance, that's where your application will get routed to. So if you live in Bloomington, and that's the office that's going to be taking care of your issue. If you live in St. Joe, it's our South Bend office that'll be handling your issue. Unless you apply under a special project like that I mentioned before, those projects go statewide. So it's possible to be living in Bloomington, but being helped by a project that's technically run out of Indianapolis. With regards to evictions, those are handled by local offices for the most part. The types of issues that we can assist with. People think of eviction as, one thing, and I think of it as an umbrella. We can assist with issues like lockouts. If your landlord locks you out, which is not legal, without a court order, it's not legal. We can assist with that. If your landlord shuts off your utilities, we can assist with that. We can assist with negotiating with landlords. A lot of times I get applicants who are just saying, I just need, my landlord to give me an extra week. And, we don't get along very well. So maybe a third party coming in and explaining that, or you talking to their attorney would help. And then I email the other attorney and just say, hey, my client's about to get rental assistance funds. Can you give her an extra week before you go file this eviction? And after that point, she starts a job, so she'll be able to pay it. Sure. And a lot of times those come to more amicable solutions and easy solutions, and we can even prevent an eviction from being filed. And so I got to say, those negotiating situations are really beneficial. And I think sometimes it does help to have a third party, which would be us, come in and kind of negotiate on your behalf. So we can do that as well. Habitability issues. Habitability is just a great big word for when you have bad conditions in your apartment, your landlord is obligated to take care of certain things when it comes to sanitary issues, safety issues, heating issues, plumbing. Those are things your landlord is supposed to maintain. So we get people in here saying there's a part of my roof that's missing and my landlord won't fix it. My kids are getting bitten by mice. There's mold in my bathroom and my landlord hasn't done anything to fix it, even though I've complained a whole bunch. We can assist with those types of issues. Threatened evictions. So even evictions that haven't been filed, your landlord just says, I'm tired of this, I'm filing next week, or I'm going to file. That might be a situation where you apply with us and then we could contact, and then that could turn into a negotiation where we just say, look, they're going to mow the lawn and you're going to give her an extra week to pay the rent, things like that. Improper notice. So if your landlord says, hey, surprise, I want to, sell this house, you have to be out tomorrow afternoon. Obviously that's not okay. There's certain notice requirements under statutes. And we can again assist with that and enforcing those notice statutes. So at least if your landlord is going to do something like that, you get the proper amount of time that you're owed under statute to be able to move your family and move your possessions to your new housing and find new housing. And lastly, a big thing that we help with is needing to retrieve your stuff after you've been evicted. I'm actually working on a case like this just now where just, us saying, look, I know that they've already vacated, but they've left a lot of personal items there because they weren't expecting it or they weren't prepared for it. They weren't able to pack things up, single moms, people with jobs, or, people who are disabled. A lot of people struggle to do that and people don't understand it. And we can help facilitate that as well. So, yeah, those are just kind of a broad overview of kind of the services. But if you have an issue that you think, I think the negotiating one, a lot of issues come in under that, where if you have a disagreement with your landlord that's affecting your living conditions and you're fearing that eviction might be filed, there's no harm in applying with us. And if we don't think that we could help with it, we'll let you know. But if we can, again, you're better off than you were before, at least knowing more about your issue. When should a tenant contact Indiana Legal Services? This is a big one. A lot of people think that, they need to only file an application with us when, they've got the eviction notice from the court in their hand. This is not true. I'm going to say the sooner the better. So if your landlord is saying like, hey, you have 10 days to be out, apply with us on that first day, because the longer we have to look over your application while you're still in the home, in the unit, is the longer that we have to figure out a solution and whether or not we can assist. There's a lot of times cases that if I had learned about them a week ago, we definitely would have been able to work on, but then we hear about it a day before the hearing and all of our attorneys are already in other hearings or at capacity. We don't have the ability to plan for it. And we may not be able to help in certain situations where we would have if we only had gotten the application earlier. So apply when you start having issues. That's the biggest thing I could say. You definitely can apply the day before hearing. You definitely can apply when you get that court notice or when you get the notice from the landlord, but you don't have to wait for that. That's the biggest takeaway I can push on that one.
That's good to know, Kylee. Kylee, I don't mean to interrupt, but that's good to know because we have clients who call the office, and unfortunately, they've waited until the day of, or, and what they will say is, well, I didn't know I could reach out, before that.
Mhm.
Or I needed to have a case number in order to be able to, apply for, to submit an application to Indiana Legal Services. So we push that too, apply as soon as you can, or as soon as you're aware of the action. So someone can assist you with that. So that, we'll make sure to continue to push that as well.
Yeah, they do not have to wait in any way. We have people that call us and that's what it is. It's, or I didn't think I could. And those are usually the ones where it's 2 or 3 days before a hearing. And just due to our capacity and our ability to plan and prepare, we're going to be able to maybe get you some advice before you do that. But the
Right.
sooner we have to basically review your application, the longer we have to do so, the more information that you could potentially get, the more advice you could potentially get, or even full representation, depending on your issue, depending on our capacity. But yeah, I'm glad that you're pushing people not to wait, because that's perfect. That's what we would like to see. Because I really do. I hate it when I'm like, this case is ridiculous. This landlord is, oh my gosh, we could probably help. When's the hearing? This afternoon. And there's no way anybody could take it. And so, yeah, do get to us as soon as you can. I'm really glad you pushed that. But good. So Diana's already talked about this a little bit. Are there any special provisions to help with people who are being evicted due to COVID-related financial hardships, or even just financial hardships in general? Right now, all there really is in place to help people who are unable to pay their rent, whether or not it's because of COVID. If you lost your job because of COVID, you're not in any worse of a position than somebody who lost their job for reasons unrelated to COVID. So if you are struggling right now with financial issues related to your housing, the only thing that's in place right now to help is the CDC moratorium. So if you are being evicted on the basis of non-payment of rents, the courts are supposed to take that into account and not evict you. That's unfortunately not what we see happening a lot. Landlords can get creative and they say, well, I'm not evicting her because she's 2 months behind on rent. I'm evicting because she, the screen door is broken and she was supposed to fix that. Or, or any other lease violation. I'm sure that if we look through our own history of rental, maybe I shouldn't have painted that wall or hung up that picture frame in my apartment. Anything could turn into a lease violation. And some courts that are, particularly more warm to landlords are picking up on those. So even with the moratorium in place, the protections are not perfect right now. And unfortunately, we don't know whether or not the moratorium is going to be extended. So as we end the moratorium, as we get nearer to that, it's becoming more of an issue for people who are behind on rent, which is why I'm super glad organizations like the one Corey runs are out there. And I'm super glad, because I didn't know that you could apply even before you would receive threats of eviction. So I think that's wonderful to have learned, because then I can tell people who are maybe it's still in that early phase that come to us, you need to be doing that. You need to get on that. So I'm glad to have learned something as well. Other than that, how does ILS assist a tenant in the eviction process? So this is a big one. This is what I do almost every day. We can advise. So if you come to us and, in a situation where we know that you're probably going to be successfully evicted, or if we don't have the capacity or any other reasons that we at that time cannot take that case, we make sure to detail advice on what the hearing is going to look like, what your rights are at the hearing, what arguments you should be bringing up at the hearing, when to present evidence, what kind of evidence you can present, and what's relevant to your case, and just inform you about your legal position and your options. And that's the kind of advice we give. This isn't where we send you a flyer. This is where an attorney, most often me, is sitting down, looking at your issue and being like, if this was me, this is what needs to come up at hearing. This is what needs to be said to the judge. This is what you can ask the judge to do. And a lot of people don't know how capable they are, because they don't know what they can ask for. A lot of people don't know at the end of the hearing, you could say, Your Honor, I just need an extra 2 weeks because I get my paycheck then, my first paycheck from my brand new job. And a lot of people just get in there and they don't know what they can say. And so informing them at least about the process, the idea is to empower people to at least be able to be a better advocate for themselves, even when we can't take that case for representation. So that's what we aim to do with our advice. There's oftentimes we also give pro se pleadings. So basically, we're going to get, especially with the moratorium, where it was giving you something to file with the court to indicate that you are protected by the moratorium, which is the renter's declaration, or indicating that you would ask for a stay until, your renter's assistance money can come in and things like that. And we can draft and provide those to you. So even when we can't represent again, you can be filing something with the court on your own behalf. We do offer representation.
Kylie,
Oh,
Kylie,
sorry.
I have a quick question for you about that renters declaration. What happens if, who enforces that if either of the party violates it?
That's a great question. I think that the answer to that would be is that the courts are supposed to enforce that and kind of be the referee on that, saying, because there's certain things when you turn that in that you're attesting to. So that you're swearing that let me see if this is a good test for me. So that I am behind on rent, that I need more time or some kind of assistance and be able to pay, that I qualify for the moratorium based on my income, and that I'm making my best efforts to pay rent, whether that's partial payments or seeking rental assistance, and that I am likely to become homeless if I am evicted. And those are what you're supposed to be swearing to. The landlord is allowed to challenge that. The landlord's about to say she's not making her best efforts. And at that point, the court, often does say, okay, tenant, you need to prove that you're making best efforts. That's why when I go into court, I love to have things from, Corey's organization that say, thank you for applying for rental assistance. Well, you'll hear back from us in 2 weeks after we process your application and things like that. And I always bring those in to prove those. The other thing I've seen sometimes is judges who will on their own will say, well, I want to see best efforts up front. And then there are some judges who just take the declaration and then they say, this is enough. This is what they were supposed to sign. So the courts are supposed to be doing that. I wish they did it a little more in a way that would be more compassionate to tenants, because right now I've had a lot of tenants sign that and really need that assistance. But then, the judge says, well, you didn't make enough applications for rental assistance, or you didn't try to pay, enough times, or you didn't have any money. But a lot of times the courts are also enforcing it. So it's kind of a mixed bag.
Okay, thank you.
Oh, no problem. And then the last thing, as far as what ILS can do, is something I've already kind of talked about and sold before. It's the negotiating with the landlord. Even if you're already in the middle of an eviction, I've negotiated after these evictions have been filed saying, hey, landlord, you might not know this, but my client's already applied with rental assistance. Can we maybe agree to hold off on hearing? And then we get to the hearing and I say, I've already talked to the landlord. We've agreed to set this hearing out so that my client has time to get together that money, or my client has time to be approved for rental assistance. And that does happen. It happened last week for me. It's happened before. And so even when things feel kind of hopeless and this eviction's already been filed, there are sometimes negotiations to be had that can at least get you more time. Because even if my client in that meantime, something terrible happens, the rental assistance doesn't come through, landlord doesn't accept it, or something like that, that's still more time than you had before. Because once you have that possession hearing and an eviction goes through, you only have usually a few days to vacate. So even just, a lot of times time is the main factor for people, for tenants that we want to help, is they just need more time to figure out the next place to go. So there's not a gap in there where you're either homeless or couch surfing or having to stay with family. So that's a big thing. I'm a big believer in the negotiation parts of the services we provide. So, how does a tenant prepare for court? This is part of the advice, a huge part of the advice that we give when we advise cases. In general, I would say that you need to make sure you come with all the documentation you have supporting your side of it. So if you get to court and your landlord says she hasn't paid in 3 months, and you have a bank statement saying, here's where my check was cashed, I paid last month, or I tried to pay, or I have a text message saying, hey, I can make a partial payment, where can I drop it off? And landlord says no. So people don't often understand how much can be evidence. So they think of evidence as maybe, a bank statement. Evidence can be screenshots, can be videos that you've taken, I've presented screenshots from Facebook Messenger and Venmo in courts, and they work. I mean, as long as you can testify as to what it is, saying, Your Honor, these are text messages between me and my landlord, that is evidence. Another thing people get confused on is when to present the evidence, because they don't, because a lot of people come to us and they say, I didn't even know I could talk. I didn't know when I was supposed to talk. And attorneys have that. Especially as a young attorney, I get in there and I'm like, is this my turn? Is it my turn yet? And the big thing I would say is that there's going to come a point where usually your landlord gets to go first and they're going to say whatever they want to say. You probably don't agree with it, probably won't like it. Then it gets to your side and they say, do you have any evidence you'd like to present to the court? This is the time where you can talk about your case. You're testifying. Testimony is evidence. So when you're just saying, Your Honor, this is what actually happened, you're allowed to do that. And this is the point where you also say, I also have text messages from my landlord saying he won't accept rent, or cursing me out, or saying I'm not going to fix your bathroom, or things like that. That's the time to do that. And then the next thing I would mainly like to say is, at the end of it, ask for what you want. Because a lot of people get in there and the landlord says, I want him out. I want him to be evicted. And then it gets to your side and you show them all this stuff of why you shouldn't be evicted, but people leave off that last part and I should not be evicted. And this is what I'm asking for. Your Honor, I just need 2 more weeks to come up with the rent. Or Your Honor, I would like extra time because my husband is disabled and it's going to take us longer to find a new place, or it's going to take us longer to move all of our stuff. So even when eviction is inevitable, there are times where you can still say, Your Honor, I would ask, that I just get more time, or I would ask that, that I have until the end of the week so that I can get a storage unit, or things like that. And judges appreciate that because they have to be told what to do. They have to be the one, they have to be asked, what you want, and they won't know what you want unless you do that. So you're completely allowed to say, Your Honor, this is what I want you to do. And that's exactly what you should say when you're done presenting your evidence.
Okay. We have
I
a
think
question from one of our guests, Laura.
Hi, Kylie. So
Hi.
thank you for the information, but one question came to mind based on information that Corey shared. And I think Diana asked a question about landlords assisting the tenants in applying for the assistance and so forth. Have you had any cases, and does your agency represent landlords that have tried to get their tenants to, there's all these resources out there, but sometimes there's tenants that just don't follow through? Do you
We do
have?
not represent landlords. We represent only tenants. So even I actually have seen applications where a landlord is saying, I want you to help me get this tenant who is destroying the house out of here. We don't represent landlords ever. But what I do think is good is there are times where we get an application. So say we get an application from a tenant who is, oh gosh, I just don't like my landlord. I can't work with them. And this is what I really want. That's a situation where it's super well, and then especially when the landlord is reasonable and maybe the tenant is being, very, they're very upset about something in their life, and so they're not willing to communicate with the landlord. That's a great situation where we could come in and say, look, we know you don't like your landlord, but what do you want out of this? And then would you allow me to go talk to your landlord and see what they want out of it? And maybe we can have a solution. And I've had situations like that before where, gosh, I can't even look them in the eye. I just don't like my landlord. And the landlord says, I just need, rent. I've got bills too. I need to figure this out. And then that just involves me explaining, to the tenant that they can apply for rental assistance and that it would limit, even if they don't like their landlord, this is in their best interest. So even in those situations where, the landlords are being reasonable and they're wanting to help, which absolutely exists, it does help us for those tenants to come to us and at least have that buffer, or that person who's explaining to them, your landlord is being actually reasonable. I think we can work something out.
Okay, thank you.
No problem. The last thing about hearings, attend your hearings. Go to your hearings. If you are having trouble getting to your hearings, you can call the court. This is the biggest thing is people feel very removed from the process because it's super intimidating. Like, who wants to go to a courthouse and ask for things, especially if you're not a very confident person or if you don't have good experience with the legal system before, which hardly any of our clients do because, unfortunately, it's difficult to be a person of low income in this country. And if you are that kind of person, I think that coming to ILS and at least getting advice and letting us know your rights, you are allowed to call the courthouse. You are allowed to ask the judge for things. You are allowed to talk to court staff. You're allowed to submit your own exhibits beforehand. You're allowed to do any of that. And just knowing that you can, and that, you know, if you don't know what time your hearing is, you can call the clerk. You're allowed to call the court. It's not going to count against you. It's not going to hurt you. Keeping the court updated as to your address if you do vacate, or, you know, in any proceeding, even if beyond housing, communicate with the court, call the court if you have questions. There is a website called My Case, which is where it's a public record of all of the cases in Indiana that are ongoing and from the past. And so if you need information, or if you want to see what's been filed in your case, you can go onto My Case, and it has a record, and you just would search your name or the cause number, or even the attorney's name, or even your landlord's name, the other party. See, there's lots of ways to find those on My Case, that information. But attend your hearings, communicate with the court if you're afraid you won't be able to make it. You know, if you say, Your Honor, on that day, my kid has an appointment at Riley's in Indianapolis, I really can't be on that day. There's a way that you could go to the court and ask the court for what's called a minute form and say, Your Honor, I would ask for a temporary stay and for the hearing to be rescheduled because I have a sick child that needs to be at an appointment on this day. I cannot make it on this day because I started a new job on that day. You are allowed to communicate with the court. That's not just for lawyers. And a lot of people don't feel very confident, but I'm saying feel confident because it's absolutely your right to do so.
Kylie, I see a hand up, and I think that's Corey who has a question. Corey?
Yeah, I have to turn my video off, but while you're talking about this, I thought about something else about ERA that might be beneficial. That I'll put it, Miss Diana, I'll put it in the slide for next week, but I'm going to read it real quick. But we can allow housing stability services, and eligible expenses would include services such as housing counseling, fair housing counseling, case management related to house stability, housing related services for survivors of domestic abuse or human trafficking, attorney's fees related to eviction proceedings, and then specialized services for individuals with disabilities or seniors that support their ability to access and maintain housing. So that is a category that can be eligible. Honestly, we haven't seen any of those requests come through in our conversation, but I can expect, in the coming months with increased eviction hearings and things that we may be able to, solicit those bills and things like that from the tenants. So that's on the tenant side of stability services. So that might be good for you guys to know, Kylee, even though you guys don't charge for your services.
No, that's wonderful, because the more we can refer people to places, especially, so say someone's not eligible for our services, they might make a little too much and not have enough expenses to kind of temper that. We could say, they have these services. I love hearing about other community services because we refer people all the time. So I'm like I said, I'm super glad I heard Corey's part, because I was like, oh my gosh, that's such good information. I got so many notes. Another thing, let me see, what's the next part of this? Sorry, I got lost. Like I said, what if you have evidence to present and when to present to the judge? I've kind of already covered this.
So Kylie, I have a question about that, because oftentimes our tenant or callers will say, well, I have all my evidence on my phone. What do I do? Do I take my phone in? I can't take my phone in. So what's the best option at that point in time? If they don't necessarily know how to, say, for example, email the evidence to
The
to
clerk
themselves, or et cetera, that type of thing, right? So what's the best practice in that case?
Well, I can tell you what we do. What we do is, I always say, and sometimes my exhibits are very funny because it looks like, it's just a huge screenshot of messages.
Mm-hmm.
Taking screenshots of those and even saving those as pictures, and or so, like taking screenshots, sending it to yourself. Even if you go print it out at your local library, we send a lot of people to library, UPS, where you can get things printed, Staples, Office Max. And so, and what's nice about those places is you can say, I have this picture on my phone and I need to print it. And there are people there who can assist with that. UPS, especially, shout out to UPS. I've had a lot of clients, a lot of tenants say, I went to UPS and they helped me get this printed. So even if you have to go to court with a printed, thing of your messages, a printed page, that's admissible. It is hard when it's still just on your phone, but I would say ask around to any people who are more tech savvy on how to turn that into a file as opposed to just the scroll of text on your phone. But that is a huge issue. I'm glad you bring it up, because a lot of people especially that we see, are just not in the position. They're like, I don't have a fax machine. I don't have a car. I don't have the ability to get there. I'm disabled and I don't drive. And the buses don't run in my area that late to where I actually, I'm not working and I can get to the library. So that's a huge, just general access issue that we see, and that, again, that we can help with. There are times where we definitely consider that. If I have a application come in and the client says, sometimes I can't read very well, or I have no internet in my home and I'm already homeless, or I'm living out of my car, we have no ability to do that. That's not going to not be a consideration when I'm saying, should I give this person advice? Do we have the ability to take this? Because for me, that person isn't going to be able to take advantage of my advice if they can't print these things out and actually, get themselves to the courthouse. That's absolutely going to be part of my consideration when I'm looking at an application to accept for any kind of services. So let us know that in your applications. If I don't have the ability to get to a Staples to print this out, I don't have a car, I don't have the ability to make it to court on time, I don't have a phone that I could even participate in Zoom in. This is my mom's phone that I'm calling from. Let us know. Diana, when Diana contacted me, she mentioned something about the landlord tenant settlement conference program. This is a program that exists, and I can't speak too much to it because, at least in my experience, in our office's experience, and as far as I know, across ILS, because we're very connected as a firm, even across the state, especially with COVID, everybody's talking on, Teams and things like that every week. I have not seen this program often utilized. It's not used in my experience. I have not seen it used or heard of it used very often. Maybe that's because, they're off getting this solved before it gets to ILS. But I think a lot of, it's a really good idea, but it just hasn't been fully implemented, or realized yet. And I haven't seen much traction or utilization. Not to say I don't think that negotiation can't be good, but I also think that there are some situations where it's not appropriate. If your landlord is filing an eviction and you're $2,000 behind, there's not much to negotiate on that. I mean, maybe with timing and things like that, but I think that for the situations that fit that, I think the idea of this settlement conference would be great. I just haven't seen it used, and I don't have enough experience on it to speak to it in depth or anything like that.
And that program came about from COVID, right? I mean, that was part of something that was that developed during that time, because I don't remember seeing it before that.
I don't either. And so if it wasn't developed specifically, in light of the pandemic, it's certainly gotten a lot more buzz about it in light of the pandemic. I think what I struggle with the settlement conference, just personally, just the idea of the conference, is usually that when landlords are reasonable enough to want to participate in such a conference, if they want to sit down with the tenant, it usually doesn't get to the point where they need that third person. If there's both parties are willing to talk things out, or just say, if you can give me till next week, or or if you can give me till next week and then I'll come and fix the pipe, or things like that. Usually that doesn't get to that point. I'm not saying there's not a place for it, but just in my experience, like there's probably a lot of times that legal issues don't get to us because both sides are, hey, we have a good relationship, let's talk this out before it even gets to the point where we need an attorney. So that's just from my experience.
Yeah, I thought it was kind of interesting that they have that information out there. They have the program out there. It's like a mediation program before anything is filed, but who enforces it? If at this, who enforces it at the end of the say, for example, there's no resolution, or the resolutions were violated, et cetera, whoever, by the landlord or by the tenant. So,
and that's at which point it goes to court. Usually the landlord goes to file, and I have the same, I have hope that this is going to be more utilized and more realized as an idea, but I have similar, reservations and questions about, what would need to be addressed going forward is definitely, who brings the parties together and how are these facilitated, and what are the promises made to either side? Is it more of just in good faith, I'm going to try to pay you by the end of the week, or is something going to be written? So things like that are just all considerations. For now, we definitely do those types of services. Right. We definitely are, like I've said, very willing to be the middleman. And often those cases are good for us because they're not as time consuming. And I don't want to say that, in a sense where we don't want to spend time on people's issues. But if something can be resolved in an email to a, opposing counsel, the landlord's attorney, rather than having a hearing where both sides have to come and spend half their day at the courthouse or on Zoom waiting for their hearing, we're able to handle a lot more of those negotiation type situations in the same span it would take for somebody to commit to one hearing. So I really appreciate when people come to us in that negotiation phase, because sometimes it is just an email, and people are just like, oh, they agreed to that. And I said, yeah, I just emailed opposing counsel, and once the personal history was removed from it and two people just were representing each other's interests, things get done sometimes more quickly than you would think.
So I do have a question about the landlord situation. So is there a cap on the damages that can be sought by a landlord?
It's 8,000 in small claims, but that doesn't prevent them from going outside of small claims court and filing. Small claims is where evictions are handled. So if your landlord is filing to evict you, they file in a small claims court, and then they can file damages. The interesting situation, which I think that your question kind of centers around, is the fact that right now people are owing a lot more than they used to. Before COVID, people would be 1 month behind, and then the landlord say, okay, you can't pay by the end of these 10 days, I'm filing. And then they would get filed, and those damages would be 1,000, plus some fees or things like that they're seeking, or any damage to the apartment or something like that. But now they're much greater amounts. And I think that's something that we're going to continue to see, and that we're going to have to grapple with, is the fact that landlords are becoming debt collectors, as it were, especially in the absence of rental assistance. When people don't know about rental assistance until it's too late, once they're already out, rental assistance won't be preventing an eviction at such a late stage. Because if you're going to be out tomorrow, the rental assistance is great for preventing homelessness, but I also think of it as a tool to limit the amount you're going to owe later on, limiting a debt that you would be ended up being liable for in the future. And so I think that's why I'm such a big proponent of people seeking out rental assistance and wanting it, because even if you don't think of it as, this is going to keep me in my house another month and it's going to do this, it's also, if your landlord does eventually evict you, unfortunately, which may happen, then this is limiting the amount. And it's proof too. You can just say, here's the email from rental assistance that approved me for $2,000. So I don't actually owe my landlord this $2,000. I only owe this much money. It really does help going forward with the amount of debt can get incurred against you by a landlord.
Right, because that moratorium didn't relieve a tenant from their rental obligation, right?
No, not at all. And even when people are protected by the moratorium, every judge that I've been in front of has been reminding the tenant, this isn't absolving you of paying this debt. So if you're protected for 3 months by the moratorium, during that 3 months, that's accruing. That's how much money you're owing, and it doesn't stop the landlord from putting on late fees. And yeah, I would say that even if, even just beyond trying to show that you're making your best efforts to pay, if you can pay anything in that time, beyond what, if you're able to, I'm not saying spend your grocery money on it, but if you're able to make, smaller payments here and there, it really will limit the amount the landlord can collect later.
That is so good to know. Now, I know we refer many of our landlord tenant based situations and evictions that might not have that component where they believe their rights were violated under the Fair Housing Act. And so we know we refer a lot of folks to Indiana Legal Services, and we have had good feedback from some of the clients that we've sent over. So we know that the system is working, and so we do appreciate that. And but we always hear, even before they reach out to Indiana Legal Services, like I asked before, how do I present my evidence if it's on the phone? Or I don't want to go to the hearing because I'm afraid, I'm afraid of what's going to happen, or they're going to kick me out, or this is another eviction on my record. So with that said, the evictions on that show up, that appear, say for example, a landlord may not necessarily know that maybe there was an arrangement made on a prior eviction that the person has. So this leads to what? Higher deposits, maybe perhaps a non-rental based on that person's record, et cetera. Is there anything that Indiana Legal Services can do with that, with the previous, evictions on the records, that type of thing? Maybe now the COVID eviction, that type of thing.
Okay, this is something I feel super passionate about. The state of Indiana, unfortunately, does not currently have what we would call, I guess, an eviction expungement statute. That means when any eviction, this is one of the things that I think tenants should know. When any eviction is filed against you, it is on public record. This doesn't mean that, when you actually get evicted, when if your landlord wakes up and says, I don't like Joe, and I'm going to go down to the courthouse and file an eviction against Joe because I don't like his t-shirt today, and I don't much agree with it, and he's current on rent, he's a great tenant otherwise, even if Joe wins in court, and he's the tenant, and he says, Your Honor, this isn't properly here, and the Honor throws it out and dismisses it, that eviction filing stays in your record. And a lot of times when people are looking for housing, especially in areas where affordable housing is really competitive and not available, that can really harm people. And during COVID, there has been a renewed discussion over seeking eviction expungement, because people, I hate to say it, but people who would have never been affected by eviction before are being affected by eviction. People who have never had housing instability before have housing instability now, and may have one or more evictions on their record in light of the pandemic. And so there is a renewed discussion that we've been hearing in the legislature talking about it. I don't think it's gained as much traction as we would hope, but currently there's nothing generally to be done about evictions. Now, in a few situations, evictions have been sealed from public record. I think that this has only happened 2 or 3 times in Indiana. So for 2 or 3 people in Indiana overall. But it is definitely something that we as an organization are very much interested in and following, because I do think that, especially in light of COVID, there are going to be people who have 2 or 3 evictions on their record who maybe never would have had it before, and are going to make it very difficult for people to find housing later on, which as a state, you would think we don't have an interest in making it hard for people to be housed, because when people aren't housed, their health, outcomes decline, they're not able to get to work, they're not able to house and feed their kids, and then that becomes an issue. So I would hope that this idea gains more traction, because for the same reason Diana said, it's very impactful for tenants, and that's the hardest conversation I have with applicants, because a lot of people apply with us saying, I just want to make sure to get this eviction off my record. Is like the number one thing they want, is I don't want this eviction on my record. And I have to have this conversation where it's not really possible right now. It's not really feasible to do that.
Can a landlord go in at any time on an eviction and say, for example, well, I don't know if the landlord can request the courts to do that they perhaps update the outcome of that eviction? Is that any?
See, what interesting is when you do a public record search, it just comes up as a filing. If people are more interested, they could go to My Case or something and then click in and say, wow, the landlord filed to dismiss this action. Like, they could look, or what landlords could do is, if you do have a good relationship with your landlord, or your landlord filed, I don't say accidentally, but an error, you weren't actually behind, and then your landlord feels bad enough about it, you could ask for letters of recommendation, or like a positive standing letter saying this was a good tenant, the filed eviction, was a mistake or was a misunderstanding. But no, not even landlords, if they came in. I mean, if the landlord maybe agreed to a sealing of the record, that may make it easier, but courts are the actual decision maker in that. So a landlord can't go in and unilaterally say, I want this off this person's record, what I did wasn't fair. The court still has to do it, and we have seen a lot of pushback from very, more warm to landlord judges who are not willing to do this, because they feel like it's the right of the public to know, the right of business owners to know who they're renting to, and things like that. So unfortunately, there's not much landlords can even do once they filed. And then I don't know if landlords are even aware that how much of an impact even a filing has. There's this idea where, well, they weren't actually evicted, but I've had clients, ILS has had clients where the same landlord has filed 4 or 5 times during the pandemic. That's 4 or 5 evictions on the same person's record. And even if that looks strange, think about if you're a new housing person. I always think, if I'm a property manager and I have 2 candidates, one with only 1 eviction on their record or even none, and they're both have the same job, same income, and then the other one has 4 or 5 from the last landlord, even if they're dismissed, what that tells me is, wow, that seems like a very dramatic situation, or that, what happened there. And so it really does harm folks. And I would really hope that landlords would understand a little bit more about what they're putting on someone's record and how much it can affect someone moving forward in their life.
Absolutely, I agree with that. It is extremely harmful, and a lot of times that's where we hear the complaints. You know, that it's on my record. So, Kylee, any last thoughts that you would like to share with this group before I turn it over to the group for questions and answers?
Yes, the things tenants should know, like I've said, attend hearings. I would say to dress for court when you go to court. So, you know, people used to say back in the day when, you know, dress like you're going to church, or dress like, you know, or things like that when you're going to court. People may not, you know, go to church, you may not be religious. So, you know, take that for what you will. But I would say it doesn't hurt to present, you know, a put together face to the world when you're asking the court for anything ever. But especially in housing court, when the odds are stacked against you, if you can present yourself as well as you can, why wouldn't you take that opportunity?
Right.
Another big thing is hallway hearings. Hallway hearings are a negative term that attorneys, or at least legal aid attorneys, use for what I hear happens way too often, unfortunately. A tenant will come to the courthouse and they'll see the landlord and the landlord's attorney, or even a clerk. And the landlord's attorney says, oh, we already had the hearing, or this is the hearing, or you just need to sign this. And then they sign something and it's an agreement to vacate, or waiving your right to the hearing, or something like that. Or that person feels like, oh, you know, the person in the suit is telling me that we need to talk about something before the hearing and make this agreement. And it's intimidating. It's intimidating being in a courthouse. It's intimidating being in front of an attorney. I get intimidated being in front of other attorneys, and I am an attorney. So what ends up happening is people get evicted, or even agree to their own eviction just because they don't wait to get into the hearing. Or sometimes, you know, unfortunately, you have court staff saying, well, you know, this can't happen, or they say something to you that discourages you from participating in the hearing. If you have that happen, if you go to court for a hearing and you never get in front of a judge, you have not had a hearing. I would encourage you definitely to report it to ILS and come talk to us, because that's something we're very interested in preventing and happening. But you do not have to talk to your landlord's attorney before a hearing. You do not have to participate in settlement talks. If you think your landlord is, you know, not trying to reach out to you to solve a problem and is just using their attorney to try to collect rent from you, or, you know, if you don't have an interest in speaking to them, you don't have to. What you do have to do, you should come to your hearing and talk to the judge about it. But don't feel like you should be intimidated or manipulated by the presence of an attorney, or even court staff sometimes, you know, trying to maybe put you off of it, participating in your hearing. Come to ILS if that happens, but make sure you show up to your hearing and you actually get in front of the judge, because that's the person who is going to be the one that gets to decide whether or not you're out. It's not court staff or opposing counsel. Another big thing is that the landlord has to take you to court to get you out. Your landlord is not allowed to shut off your water. Your landlord is not allowed to shut off your heating. Your landlord is not allowed to change the locks. If they do that without a court order, you know, don't get me wrong, if there's been a court order and you've already vacated, they're allowed to change the locks at that point. But without taking you to court, they are not allowed to do so. And there is something called an emergency possessory hearing that you can request happen within 3 days to let you back into the apartment. And you can even get damages for, say you have to stay in a hotel for those 3 days. You can get the landlord to have to pay you back for that. That's a process that a lot of people don't know about. A lot of people call us a month later saying, a month ago, my landlord locked me out or turned off my water, so me and my kids had to leave. That's not okay. Your landlord is not allowed to lock you out or turn off your utilities.
Kylee, what if they remove their personal possessions within that time frame? I mean, can the tenant then also request damages for that?
Yeah, so if your landlord goes in and damages your property out after an illegal lockout, yeah, there's lots of things that you can request damages for. Like the damages process is pretty flexible in what you could ask for. So some people, I had to miss work because I couldn't get my kids to daycare because we were locked out and I couldn't dress for work because all my stuff was in there. And so you lost a day's worth of wages. That's absolutely relevant. And a lot of people, they kind of give up after this point. They're like, you know, my landlord locked me out. It's kind of over. It's done with. They have to take you to court. You have rights as a tenant, and part of that is to be heard, even if the eviction is absolutely going to happen. You have no defense to it. Your lease is over. You haven't paid rent. All this stuff. they still have to do that. And what that does is it also gets you more time and demonstrates the landlord's bad behavior, which doesn't hurt to show the court, because then sometimes if you're asking for more time for somebody who's been locked out and the landlord has shown bad behavior, it never hurts to show, you know, that you were in the right and that the landlord was not doing what they're supposed to be doing as a landlord.
Thank you for that.
And then the last thing is keep documentation and pay rent. Outside of COVID circumstances, even if your roof is caving in and your bathroom's flooding every night and you have mold crawling up the walls and it's horrible conditions, if you haven't paid rent, your landlord can get you out based on the fact you haven't paid rent. So if you continue to pay rent, you know, it seems horrible that you would have to pay rent while your, you know, roof's caving in, but you do. But then that gives you the amount of time, you know, they won't file an eviction, and then that gives you amount of time to seek your rights, to make your landlord, to enforce your habitability issues, to make sure that your landlord has to fix those. But I would say pay rent, and then, like I said, keep documentations. A lot of people come to us and they say, I don't have I have no written lease. It's just an agreement between me and my friend, and now our relationship's gone sour. It's month to month. I don't have any paperwork about it, but I paid him cash every month to stay here. If you can even just pay them, if you're paying cash, send a text message saying, hey, you got, I gave you the full amount, right? Or, hey, I left the cash in your mailbox in an envelope. Did you get it? Keep records of things. So you can find ways to keep records of things, even when you have a very informal lease. And then my last thing is just apply. I think that more people are eligible than you think. And even if you just leave with some good information, it's more information that you had before, and it will help prepare you for the future. So even if you get advice on this one, you'll at least know going forward when you get into other housing situations, what your rights are and what you're allowed to do.
Kylee, wow, thank you so very much for all that information. Incredible to hear, number one, what the services are, but then also just how important it is for folks to reach out. You know, don't wait till the last minute. Reach out, even if you get the advice, not necessarily representation, but something is better than nothing, especially when you're stepping into a court in front of a judge, and that you should be prepared for things of that nature. I know that we'll have you back on next week, and I'm excited to revisit the process again as well. But I'd like to turn it over to the audience. Does anyone have any questions for Kylee at this point in time? And while you're formulating your questions, if you do have some, just know that in the chat area, Alyssa Allstott, who's a housing investigator, has posted some really great information going forward for you to have, including the mycase.gov, mycasein.gov link that Kylee mentioned as well. And then also we have posted the link to the webinars, which will also include this recorded webinar. And then we have a survey. We'd like to really have some input from you. So before you actually leave this particular training link, if you could fill that out, that would be great. Or if you'd like to, share with us in the chat section, that would be great as well. You can always call the commission at 235-9355. Again, that's 574-235-9355. And certainly, if you know of anyone who believes their fair housing rights were violated, please have them, contact us directly to see if we can assist them or where we need to refer them to so that they are able to receive some type of assistance. So I'm just going to wait here for a second to see if anybody has any questions or any further information. Kylee, I have a question for you. So about how many evictions, you mentioned that you had 3 evictions just this past week, right?
Yeah.
So
3 eviction hearings, 1 in LaPorte and 1 in St. Joe and 1 in Elkhart.
Okay. So what does have you handled anything prior to, the situation going on right now with this whole COVID moratorium that's, set to expire? Because I'm sure that there were still evictions being filed, correct? Even just on the basis of violations of lease and tenant.
Yeah, I actually started at ILS when I was still in law school as an intern and when I was studying for the bar. And so this was before the pandemic is when I became an intern, starting under the housing director at ILS, Brandon Beeler, who's an amazing advocate. And yeah, we would have evictions definitely coming in, but unfortunately those evictions still with non-payment of rent. Non-payment of rent is kind of the kiss of death. If you haven't been able to pay your rent, it's very likely the court's going to go forward. There's really no defense to it without the moratorium. But I would say definitely the moratorium has just been a boom of evictions. When I go to court, unfortunately, a lot of tenants are not represented. And there are times when I'm there with my client, and then when you go into court, they show you the list of other people whose hearings are happening that day. And there's 30 other people getting evicted, 30 other eviction filings. So I'm not saying that's every single day, but on days when I go to court, it is not abnormal to see 12, 30, 15, just larger numbers than, that I would like to see or anybody would like to see of people getting evicted. And so there are times where I leave court and they're like, who are you? Where do you work? I didn't know as a tenant, people would represent us. I don't have the money to hire someone. And that's what I'm like, go to ILS. Because for every one that we represent, there's those 12, 20, 30 that aren't there with attorneys that could definitely at least use some advice. So yeah, that's why I'm such a big proponent of at least applying. You're going to get good advice.
Right. I know that the eviction lab, which is through Princeton University, they offer that eviction lab, and they have information based on what evictions look like, from state to state to state. And I know that Indiana, specifically South Bend, they're tracking our numbers, and it's always been because we've had an extremely high rate of evictions. And oftentimes it's always due to that non-payment of rent. Even if it's just 1 month, you're already, seeing that. You're seeing late fees tacked onto that, and they want you out, or if they make an arrangement, there's going to be a fee going forward, that type of thing. And I know that they stated that I believe for South Bend, within the months of March 15, 2020 through January 10th, 2021, there were 802 evictions filed in South Bend. So again, absent of that moratoria, which doesn't cover everything, and you do have to qualify, right, to have that protection at least. We still had over 800 plus evictions, and when we think of an eviction, it's not just one person, we're talking entire families being displaced. So again, it's just, Kylie, do you have any thought, on feedback on that, the number of evictions?
Yeah, ILS really, we try to keep our finger on the pulse of these issues, especially because we're the ones on the ground. We're kind of unique. We're the people that are the ones representing tenants. And you know what? I really try to take the opportunity. The only thing that we can do is to take the opportunity to educate in court. That's something we really talk about. My supervising attorney is always talking about, and something I've learned under her. There's sometimes judges don't even know. And then landlords attorneys sometimes don't realize that I've had landlords attorneys who said, I didn't know that this eviction filing that I filed last month wrongfully was going to stay on someone's record, because they don't do this all the time. There's not a lot of money in tenants and protecting tenants, and
Right.
Unless you're a legal aid organization. And so they're not in those courtroom situations, and we are. So we know so much just because we're always in court with tenants. We're always giving that advice. And so we're the ones on the ground. So there are times when the judge says, oh, I didn't know it was taking so long for people to get their unemployment benefits. I didn't realize that it was taking so long. And I've had to say, Your Honor, I handle unemployment cases, and it does take that long. So my client isn't stalling when they say they haven't received their unemployment benefits so that they can use it to pay rent. She has a pending appeal, and it is taking months and months for those to go through. Or, Your Honor, actually, we need to have this hearing on this issue because the statute says this. Or, even just educating people just very politely, when you can, and just say, yeah, Your Honor, actually landlords are not permitted to do this. Or the housing authority. We take cases with housing authority too. So I forgot to mention that if you having issues with your voucher, with your public housing, we help people with that all the time. I handle those cases as well. So if you're having an issue where public housing isn't doing something, or if you're having an issue with, they're going to revoke my voucher, come to us as well for those issues too. We handle those and offer advice as well.
Thank you for sharing that. Do you also handle landlord, no, oh gosh, oh gosh, what is it? The rent to own agreements where there might be an issue with the verbiage in that they're saying, hey, landlord contracts, it turns into a rental at the end of the
Yep.
verbiage, but you're really buying the house. That's what you were told. So
Yeah, we do, especially because those situations present. So yeah, if you're having an issue with that, saying now my landlord he's supposed to sign over the title, but he's not signing over the title now. Or he's saying I owe a lot more than we need to, and all you have is a printed from, Microsoft Word printed document that you guys drew up together when you guys were on good terms, and now that you're not on good terms, he's refusing to do something or perform or accept payment or something like that. Yeah, that's one of those negotiations. That's a big situation where we use those negotiation services where we're just like, let's contact something and we'll try to, navigate this. But yeah, we absolutely do. We also help with mobile home issues. So, if you're, a lot of times there's the issue of my mobile home is paid off, but I have to pay rent to the lot manager, and there's an issue there. We help with that as well.
Okay, great. Thank you for this information. I really appreciate that. And I'll probably have additional questions the next time around when I see you on the 24th. But I'd like to thank you especially for allowing us the opportunity to pick your brain, but then also everything that you've shared with us as well. And Corey as well, thank you so very much for your time, both of you. The commission really appreciates you taking time out to do this. 2 hours, I get it. It's a lot of information, but
Do it. I learned a lot too, and honestly, this helps me. This is getting out, and people. If a lot of times, if people knew their rights, sometimes these issues wouldn't turn into issues because people just need to be informed and be empowered to stand up for yourself and enforce your rights.
absolutely. So with that said, I will be calling both you and Corey again later to set up additional informative sessions and trainings as well, because I think it's important that, again, we may be an investigative enforcement agency, but, part of what we're tasked with is education and outreach. And this specifically was, again, we partnered with CDBG and Mishawaka to bring this out to our Mishawaka residents. And again, anyone who might be on the line listening. But then secondly, also, we plan to have this again on the 24th. Please join us if you're not on that email list, or you would like to be added, or you would prefer a different method of contact, say, for example, a phone call, or even just a reminder notice in the mail. We'll be more than happy to do that. Although the training is the 24th, which is next week. So I don't know if the letter will get to you in time. But with all of that said, I'd like to appreciate everyone on the line. I'd like to thank Laura and as well as Marilyn Jones for participating. And I hope to see you all on the 24th. And if there are any questions for us, feel free to leave those questions in the chat section. And if you need any further information, you can always contact the South Bend Human Rights Commission. Thank you. Goodbye, everyone.
Thank you. Bye.
Did everyone hear my last message, or I think I got cut out?